Possession of marijuana arrests in Montgomery County. Find out everything you need to know right now. Howdy, I'm Brian Foley. I'm a criminal defense attorney in Conroe, Texas. I also serve the Woodlands, Houston, that general area. And today we're going to be talking about possession of marijuana. Yes, it is still a crime that people get arrested for in Montgomery County. If you're in Harris County, that's not going to happen. There are no possession of marijuana arrests for misdemeanor level offenses, at least in Harris County. They will if you have a whole lot of it, like pounds and things like that. But let's talk about possession of marijuana. You know, the first thing that people really don't know about this crime is that you can get arrested for it, obviously, but you could also get a driver's license suspension. That's one of the reasons why it's important to get an attorney, so we can help you get it either dismissed or off your record in some way. Here's what happens is section 521.372 has a suspension or license denial. This is part of the traffic code. It says a person's driver's license is automatically suspended on final conviction of an offense under the Controlled Substances Act. And possession of marijuana is under the Controlled Substances Act. It's 481-121. So how are we going to try to get your case dismissed? Well, the first thing we're going to do is we're going to look at the evidence that the district attorney's office has. It's normally a body camera or a dash camera from the police officer. And it's going to be something we're looking for called reasonable suspicion. Did they have reasonable suspicion to pull you over? And here's the standard for that from the Texas Court of Criminal Appeals. It's a case from 2011. A police officer has reasonable suspicion to detain if he has specific articulable facts combined with rational inferences from those facts that would lead him reasonably to conclude that the person detained has been, or soon will be engaged in criminal activity. And in the Dershweiler case, you know, it was just some strange behavior, including smiling at somebody. So it doesn't have to be a specific traffic offense or something like that. Reasonable suspicion is determined as an objective standard, and it doesn't matter what the police officer's subjective beliefs were about what the law is. The judge is just going to look at what were the facts that they knew at that time. You are supposed to be able to disregard the actual thoughts of the police officer making the arrest and instead see if there's an objectively justifiable basis for the detention. Courts are also going to look at what's called the totality of the circumstances. It means everything put together. It means that circumstances that seem innocent when taken alone may be combined to predict criminal conduct. Like, that's going back to that Dershweiler case. If somebody's just smiling, maybe they have a reason to pull you over. I think that's a little extreme, but that's where the law is in the state of Texas right now. So here's some frequent examples of reasonable suspicion for traffic offenses in possession of marijuana cases here in the Woodlands. Number 1, speeding, okay? Number 2, failing to signal a lane change. This has to happen before you switch lanes. There's no specific footage that happens. That requirement is if you are making a turn onto another road as opposed to changing lanes. But changing lanes is the one I see the most. Vehicle registration sticker issues. So there is no inspection sticker requirement anymore, but there is a vehicle registration sticker requirement. And to get that sticker, you have to have in the system that your vehicle's been inspected. Invalid or obscured license plates. So if you have like a decorative license plate holder in the back of your car, just because you think it's fun, maybe it's a college or something that you went to, well, if it's obscuring part of your license plate, that could be used to pull you over. If your plate is invalid, you know, let's say it's a new car and it's past the period of time that you're supposed to have received the plates, they could pull you over for that. I've seen that too. And here's one: parking for a long time in a residential area or in a suspicious manner. So one thing that people will sometimes do if they're smoking marijuana is they will park like in a cul-de-sac, sort of away from their house. Maybe they don't want the parents to see or something like that. They'll park there and smoke in the car and stay there for 45 minutes, an hour. Well, what happens if you do that is the people in that area of the neighborhood will call and say, hey, there's a suspicious vehicle parked over here. We don't know what they're doing. Well, you could be in luck. If this is what's happened to you, there's a case where State versus Garcia, and the in that case, they decided to investigate the presence of a person's truck parked at the dead end portion of a road. The officer initiated the incident by blocking the exit of that vehicle with his patrol car and turning on his spotlight. He approached the trunk along with a long flashlight playing over the driver's side, immediately saying, "What are you doing here?" Using his flashlight to wave the passenger back area of the truck and standing toe to toe, shining his flashlight into the appellant's eyes. Considering all of that, the court concluded that any person would not feel free to drive or walk away to terminate the interview. So what happens there is if a police officer is doing that to you, if he's turned on his red and blue lights or he's put his spotlight on you and they don't really have an indication that you're up to particular criminal activity, just that the vehicle is parked there, it's not illegal to park there, then they're probably going to lack reasonable suspicion. That's how we win cases for clients, is we use our knowledge of the case law and things like this to find a way to convince either the prosecutor or the judge to dismiss the charge. There's also things that we can do for possession of marijuana cases where you could maybe complete some community service, take a class or things like that in order to get your case dismissed. And we've had pretty good success with those things. The other part that we'll use to defend when it comes to the case law side is trying to, we would call it either suppress or file a motion to suppress based on the lack of probable cause. And so in a possession of marijuana case, a lot of times these are found in vehicles, okay? And there's a thing called the automobile exception. Let me read about that for a minute. The automobile exception to the Fourth Amendment warrant requirement means that if the police have probable cause to search your vehicle, they may do so without first obtaining a warrant. And that is from Markopoulos versus State 538 Southwest 596. It's a Texas Court of Criminal Appeals case from 2017. But if they don't have probable cause, then the search is likely going to be illegal. There's a few other exceptions like inventory exceptions, but those are more rare. They probably have already found the marijuana by the time they're doing a vehicle inventory search. If you don't have a warrant or something like that for your arrest, it's going to be hard for them to justify the case under an inventory search. But here's what the police are often using in these cases. It's the odor of marijuana. If they smell marijuana coming from the vehicle, in Polk versus State, the defendant argued that the officer actually did not find marijuana in the interior of the vehicle, found it in the trunk, but said that he could smell it in the interior. Well, the court said that even if they don't find it in the interior, and that's where they said they smelled it, that was still approved as part of a legal search. They said in Osborne versus State and Polk versus State that you could search based on the smell of marijuana, and then the automobile exception allows you to search any container in the car, including the trunk. So let's talk now about recent industrial hemp developments. So in 2019, there is a industrial hemp program that was started by the state, and it allows a person to possess marijuana as long as it has less than 0.3% Delta 9 THC amount, okay? Now let me tell you what's going to happen in Montgomery County. If you are part of this industrial hemp program, you're going to have a specific license from the state to do that. You're going to have docs, like sheets of paper that control how you obtained your marijuana, what seeds you got it from, and things like that. A lot of documentation. So just saying it's industrial hemp or something like that is probably not going to fly. You're probably still going to get arrested. But if it is in fact industrial hemp and it comes back with a lower than 0.3% on a dry weight basis of Delta 9 THC, then that means you don't have marijuana at all. The definition of marijuana in the state of Texas is greater than that 0.3% of Delta 9. Now, what if it's Delta 8 or Delta 10 or something else? Well, the police are not going to be testing for these deltas on the side of the road. They're just going to see that it's marijuana, and in Montgomery County, you're going to end up getting arrested. That's why Harris County really stopped making these arrests, is because they felt like they couldn't prove by probable cause standards that, in fact, you possess Delta 9 THC. So that is our discussion today. I hope you've enjoyed it and learned a little something about possession of marijuana cases in Montgomery County. If you're looking for help with that, you can always give us a call. If you like the video, like, subscribe, give us a 5-star review on Google. Thanks so much.